You're on Senate Bill 1. We began to speak about this legislation, the House Judiciary Committee. It's Thursday the 6th, 1:45. We began speaking about this legislation on Tuesday. We've had plenty of time for people to offer amendments. The chair will not be entertaining any holds on this bill. We're going to go through the amendments and move the bill today. There was an amendment offered by Delegate Taylor. Delegate Taylor's amendments is 743023, and this is an amendment that I believe also was offered by Delegate Munoz. What the amendment appears to do, Delegate Taylor, is it your intention to move this amendment?
Do we all have this one?
You're on?
Yes.
All right. Is there a second to Delegate Taylor's amendment? And I heard a second. So again, 743023, it would strike the provision on page 7 of the bill. This is in the exceptions, and I believe it is presently listed as B, or let's get the actual citation here. Sorry again?
It's page 7, line 25.
That's right.
With or.
Right. Starting with the or. So it would strike the provision that presently reads that as an exception, a firearm that is carried or transported in a motor vehicle if the firearm is unloaded and locked in a container that is separate from any ammunition that is suitable for use in the firearm. Is that my understanding is what your amendment would do? It would strike that language.
That is correct.
All right. So as I understand it, what that does is it sends the law back to where wear and carry law is right now. And presently, a person who has a wear and carry permit is able to carry the weapon inside the vehicle. If you did not have a wear and carry permit, you have to put the gun in the car, and you could put the gun in the trunk, and keep it out of the passenger area of the car. So what this amendment does is it basically returns the law back to where it was, or where it is now, effectively. Is that correct, Delegate Taylor? All right. Are there further comments or questions about the amendment? Who? Delegate Young. The amendment number is amendment number 743023. Okay. I see Schmidt and Grammer.
Page 7, Chair. Thank you, Chairman. Page 7, I see line 19. I'm not seeing where it says
26.
Okay. Okay. I got it. Thank you.
Thank you.
The amendment I have was different. Thank you.
Line 19 is just technical. It's adding an or because we're subtracting an item number. So the or on that line 19 is just a technical amendment.
Okay, I understand.
Okay.
Delegate Grammer.
Thank you, Mr. Chair. Just to understand, this is to avoid complications that people wanted to avoid. Am I understanding that properly?
That's correct.
Okay.
And so what this goes to the exceptions. If you left it in, if we left it in, then wear carry holders would go to a different position, if they're a more restricted position than what they have right now.
Thank you.
All right. Any further comments on this amendment? All in favor of this amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. Anyone opposed?
Oh, well, is anyone opposed?
No one opposed.
Then I'd like to be recorded in the yes.
All right. The amendment is adopted. So we adopted Delegate Taylor's amendment. goes over here. Where is the, yeah, this one. Delegate Grammer, I'm looking at an amendment that you offered, Amendment 713825. Would you like to discuss what this amendment would do, please? Seven one three 825.
All right, thank you, Mr. Chair. So some folks had spoke to me that work in professional, I don't want to say law enforcement, but maybe security occupations, and they wanted to put a provisions in a law that protected or excluded private detectives, special police officers commissioned under Title III, a subtitle 3 of the Public Safety article, railroad police officers, and employees of armored car companies, people who do regularly use firearms in the course of their everyday employment. So that is why this amendment was drafted. We just want to keep these folks legal. So I would move the amendment.
So I would, I heard the motion on the amendment. We'll have discussion on the amendment. I think I heard a second. What I would say is a special police officer, as I understand it from counsel, would already be covered here. So that wouldn't, and yes, in the definition. The railroad police officer, and there's a typo in the amendment, but a railroad police, not policer, officer, and an employee of an armored car company, I could see those being added in. Would you be amenable to altering your amendments so that what is added there on D and E be added to the bill?
Yeah, I'm fine with that. But
right.
we didn't want to add private detectives?
I think private detective's a little bit different. I think it's different than the other two.
So a private detective is actually who called requesting the amendment. So their concern is that in the course of everyday duties, they're expected to be armed so they can deal with these kind of things.
I understand that as this deals with an exception, as I read it, to the sensitive places portion of the bill. I think that it's more appropriate to address the armored car company and the railroad police officer here, as opposed to a detective that could have a broader scope in what they're looking at. That's how I feel. So I'm asking if you
Well,
be willing.
I'll take what I can get then. Yes, thank you.
That I would be willing to support the D and the E.
Okay.
Members of the committee, so as I understand it, Delegate Grammer would be willing to change his amendment again. This is 713825. And it would not include sections as are listed right now, B and C. Again, C already covered in the bill. D and E would remain. Could I have a motion to accept that amendment to the amendment? There's a motion to the amendment in a second. We'll now discuss. Any discussion of that? Seeing none, all in favor of Delegate Grammer's amended amendment, please raise your hands. Anybody opposed? All right, that amended amendment is adopted unanimously. Okay. Now. Any of those. So there should be a set of amendments that you have that the committee would offer. And this is amendments 833, 728.
That's the big packet, that's the reprint.
This is the reprint.
Oh, okay.
And what I will do is go through the areas that would be affected by the reprint or the amendment that you're seeing in the reprint of the bill. So it would do the following. It would delete from the list of places under the area for children and vulnerable adults, a youth camp. The reason being, a youth camp is a movable, it sometimes could appear in multiple places, or it's not at one set location. So we deleted that. We looked at the definition of healthcare facility and kept in hospitals, associated buildings to hospitals. Right now, I'm on page 4 of the reprint, looking at lines, starting at line 20, and now going down to line 22. 3 and 4, just one of them was an ambulatory surgery center, and the other was a rehabilitation center for disabled people. We strike a location that is being used as a shelter for runaway youth. Going further, we add into the committee's amendment not just an electric power plant, but a gas power plant, a gas plant as defined in the Public Utilities article, or a nuclear power facility. We alter the definition to make it more expansive of law enforcement official, as I understand it, correct, counsel? Yeah. That's what is there in number 5. We alter and expand the definition of law enforcement counsel. We use the definition of police officer as defined under 3201 of the Public Safety article, which again expands and has a broader definition. Those were asked for, I believe, both by the chiefs and sheriffs in the Fraternal Order of Police. We strike in the list of places under the special purpose area category, we strike a location being used for an organized sporting or athletic activity, a live theater performance, a musical concert or performance for which the members of the audience are required to pay or possess a ticket to be admitted. We replace that language with an amusement park. We replace a fair and carnival with a fairground. And we strike on page 6, lines 3, we strike the reference to where you would be prohibited from possessing a wear and carry in the area of a demonstration, as there is existing law. The committee's amendment now on page 6 in the area of the exclusions. In the area of the exclusions, it's 2, one of the ones? No, that was before.
We cleaned up number 1 though.
We cleaned up number 1 to say a law enforcement issue or a police officer. And counsel, if you'd talk briefly about why that is cleaned up in that way.
So we cleaned that up.
Need the button. It'll get there.
So the reason that's cleaned up in this section and the next section is I put the definitions in, and because the definitions are there, it's not necessary to comb them all out. And if you go to 3201 and there's the other one, 4201 of CRIM law and 3201 of public safety, you'll see all the law enforcement officials and police officers that are included under that provision. So because they're defined in the bill, it's not necessary to list everyone out there. Yeah.
Is that the provision that lists like employee of the state police, Baltimore City Police, any municipal?
Exactly.
That's
Right.
okay.
So it's cleaner that way to refer to the longer list. Yes.
Has like 14 or 15, there's several sections. Okay.
That's correct. That's correct. So that amendment is part of the committee's amendment. I think because of that, that's why we deleted a sheriff or full-time or deputy sheriff, because it was in that definition. Moving to page 7, the committee's amendment does not change anything, but again, for the record, we just did amend out 26 through 30 for Delegate Taylor. On page 8, the committee's amendment would not address anything on this page, I believe, correct, except
5 through 7, we cut that because we cut
Correct. We cut out 5 through 7 because we eliminated the organized sporting activity language. On page 9, we had already, well, on page 9, we add in subsection I, which addresses the ability of a court to punish somebody for contempt if they fail to abide by rules at a courthouse, regulating, allowing, restricting, or prohibiting the possession of weapons in a courthouse. That was a Maryland Judiciary request. We reorganize section 6411. We put dwelling and the requirements with regard to dwellings first. And then, well, actually, we're not quite at that part, but you're going to see here in a second where we flipped it to put the dwelling first. We change, again, law enforcement official and police officer, as I mentioned, on page 9, in between lines 17 and 18. And the rest is stuff that's already there. What's listed is page 10. There's nothing that has changed in substance. They are reordered to put the dwelling first before the other properties or other private property references there. On page 11, the lenity language did not change, and then that's the sum and substance of the bill. Pretty much there's nothing there after page 11 except for the severability clause, which lies on page 20.
And then we'll have further discussion.
We're going to have further discussion on, yes.
I know we'll have further discussion on it, but I move the committee amendments, Mr. Chair.
We're going to move the committee amendments. Is there a second? Second. And a second. We're on the committee's amendments. Delegate Arikan, and then Cardi.
Thank you, Mr. Chair. Thanks for your work on this. Okay, I have a couple questions because it's, a lot of different changes. The first one I just wanted to mention, maybe Holly wants to just do a real quick tweak on the page 4 of 20, line 22, where it references the insurance article. I think we need to add a G there. Because G is actually, of that insurance article, is actually where they describe health care facility. Otherwise, we're referencing like that whole page.
Nope, thank you. That's
Really?
right. Yeah.
Is that right?
Yeah.
Okay.
Yeah.
Okay, good. So we'll work on that. The other thing I just wanted to touch on, so we've got these areas for children and vulnerable individuals. I'm just wanting to understand exactly why we've picked these places, why. So, and you've removed the youth camp, for example. Is that was crossed out?
So the choice that was made was to look at places that have more of a set location, as opposed to places that could potentially move from place to place. A youth camp could go from different places, and that we felt like that was not. One of the things that came out of the discussion on Tuesday night was wanting to make sure that things were as clear as possible. And so the thought was youth camp was broad and could mean any number of different things, although it is defined, but still those could move from church to church or something like that. So that's why we took that out.
Oh, okay. Yep.
The location being used as a shelter for runaway youth could also equally have sort of a fungible isn't quite the right word, but a movable nature.
Okay, so the idea would be that if somebody went to one place and it was okay, and then a few weeks later tried to go to the same place, and all of a sudden it wasn't okay.
It's different. So
okay.
It's meant to be more not to say that these places are always going to be there forever, but to say that they are more permanent than not.
Okay.
And so with the children and vulnerable adults, the idea was to have schools, private and primary and secondary schools. The public schools are in the next section because they come under public infrastructure. Mm-hmm. And then healthcare facilities. That was the reason that we kept those three together.
Okay.
We struck some parts of the healthcare facility because it included places like LabCorp or an MRI machine or things like that. So we moved those.
Definitely wouldn't want to bring your gun to an MRI machine.
Bad idea to bring your gun to an MRI machine.
Really bad idea. Okay, that helps me understand that a little bit better. And then on page 5 of 20, it sort of talks about special purpose areas.
The third category of.
Yeah.
of-
Yeah,
yes.
can you just talk me through sort of, I see, so you've removed the sporting and athletic activities, the live theater and the music concerts, but you've left in the amusement parks, and you've removed carnivals, but you've left fairgrounds. Is
We added
fairground-
fairgrounds.
Okay.
We left casino. The casino is at a set place. The racetrack is at a set place. A fairground is at a set place.
Okay,
The carnival could be at any different, it could be moved to different places. A fair could be a street fair in one part of a place and then in another part of a place. And a live theater performance could be any number of different places. And so what we did was we're seeking to bring more certainty to this area of the law. And along with the sporting or athletic facilities, the thought was that it needed to be more certain, and given that some of those activities could occur in a number of different places, we felt that it was more appropriate to strike that from here.
okay, and then for the location to sell alcohol, you know, like in my county at least, we have all of these like one-time use alcohol things. So somebody could, for example, come to my farm any other day, but if they come to my farm on the day that I'm having my fundraiser, obviously I've had to pull a liquor permit. So then now my farm will no longer be a place where somebody could carry a firearm.
I mean, that the decision was to leave that language in, and leave that language in the special areas.
Yeah, I'm just wondering, so that was the intent though for people who have, you know, just one-day permits to sell alcohol, that now their property is prohibited?
I mean, the statute or the bill as it reads, says a location licensed to sell or dispense alcohol or cannabis for on-site consumption.
So it would include
yes.
me, and that's the intent?
If it was licensed for on-site consumption, yes.
Yeah, because they give away like a one-day license for all kinds of things. Any like event like that would be, so potentially all fundraisers that are held would no longer be allowed to have anybody carry. Even with permission by the landowner, like I could not permit somebody to carry a firearm.
That would be considered an area that would be a sensitive area under the law, yes.
Okay, all right. Yes, it is my dwelling, but because it's now a sensitive area, I could not give permission to this. The state in this part of the code is now going to prevent even the property owner from deciding if it's permissible. So the state would decide that I could no longer make that decision for my property on the day that I'm holding my event and I have my license for alcohol.
There are other questions. Delegate Tomlinson, then Pasteur, then Grammer.
I'm looking at page 10 here, and I'm just trying, am I on? Okay. Yeah, I'm just trying to make sure I fully get this. So if I have a concealed carry permit and I go over whoever, it doesn't matter, my friend, my brother's house, whoever.
So actually, let me do this, because I think I have to. You're fine, but it strikes me that what I'd like to do now is deal specifically with the amendment, and I think that some of the discussions on this amendment, if they're one of the technical changes that technical and other changes that we've made, if it's specific to that, let's talk about that now. I feel like that this conversation could wander into the bill as a whole, which is fine, and we're gonna get to that.
Okay.
But I guess what I'd like to do is, if you heard something in the changes that the committee's amendments made that you want to talk about, let's do that now, and then we can take the next step. And so, is it in reference to one of the changes the committee amendment?
Originally, I had a question about the fairground carnival, but that was already
But
addressed.
we
so-
addressed that.
Yeah,
Okay.
I'm good then. I'll wait.
That's fine.
Where, which is what's
Okay.
in this amendment.
All right.
Mr. Chair.
Delegate Cardin.
Thank you. I'm not sure it's in the amendment, but I thought it was supposed to be in the amendment, so I just wanted to ask, and then if you tell me, we'll talk about this later. But on page 4, line 19, a private school is considered a sensitive place that this would apply to. And on page, 8, I think it's 8, page 9, there is, no, I'm sorry, page 7, there's an exemption for, if you have, I guess this would be like for, like, let's say a church or a synagogue. I just want to make sure I know that this wasn't intended to be in the amendment, that if a synagogue and a school are occupying overlapping space, regardless of this, I mean, I would even say if the school's not even in session, you have to actually go over the school grounds in order to get into the synagogue. I would be concerned that somebody would have permission from the synagogue, not necessarily have specific permission from the school, and they may not unknowingly violate the rule because they're traveling, like from the parking lot. Parking lot would not be considered part of the church, but it would be considered part of the school. So they park their car in the parking lot and walk into the church. Once they're inside the church, I think they're okay. But they would be in school grounds. And I was hoping that that was part of the amendment. That's just my only concern. Does that make sense to you? I'm not worried necessarily about people, that the school, calling them out on it. I'm worried about the person actually violating the law without knowing that they're violating the law. That would be my
So they're parking in a parking lot to go to the synagogue.
Right. I am a member of Beth Villa. I park in the school parking lot this morning to go to services. I then walk into the synagogue. The school's not even in session, but if I'm wearing a carrying, I'm violating the rules, right? Even though there's a separation between the church and the school in terms of maybe there's a wall or there's a hallway, there's probably enough to be able to separate them so that you're not. But you're on school grounds when you park the car and when you walk in. I just want to, and I thought maybe if it's not part of this amendment, then
I believe that the idea when we put in the amendment before with regard to school property was that somebody would seek permission from the school to do that.
So I'm a member of the synagogue. My kids don't go to the school. So how would I know I have to go to I guess I would have to go to the school, get permission from the school, even though I'm not affiliated with the school because I go to the synagogue.
But it's all part of the same.
So there has to be a relationship between the school and the synagogue to say anybody who wears carries is going to automatically be able to be okay on school grounds. You might be setting things up to be, again, it's an issue that could arise.
I understand. I believe that we addressed the issue, but having said that, while we go through some of the other comments, we can look at that again. Delegate Grammer now, please, and then Conaway.
Thank you, Mr. Chair. And this might be a procedural question as much as it is on the amendment. We can't draft an amendment against this amendment because it's not adopted. Is it possible to take a vote on a portion of this amendment? So I have a problem with one particular part of this
It would
amendment.
be the amendment. I mean, look, we just a moment ago, we said that we would take part of your amendment, but there was an agreement beforehand. I think it would be dependent on whether I decided I wanted to do that. Why don't you tell the committee what you'd want to change, and then we'll go from there.
So on page 10, lines 15 through 20, these are the parts of the bill that have to do with private property. And these are while I have some other concerns, these are the parts of similar bills in different states that have been challenged and are enjoined right now. And, as the Senate passed it, I think it made a lot more sense. So currently, if you own private property and a person comes onto your property and you say, I'd like you to leave, and they don't leave, that's trespassing. If you pass the bill as the Senate drafted it, this particular part, it would change that circumstance to be a crime to come onto private property if they posted a sign. And I think that kind of gets what we're looking to achieve here. But if we adopt this amendment, it actually, it changes that, so you're just completely banned from going onto any private property. And I don't see how the average permit holder is frankly going to be able to exist. I mean, you won't be able to get gas, marinas, restaurants. It's private property. Other than in your car and on the street, I don't see how this is functional. I think that's probably why this particular portion of the bill has been enjoined in other states. And I wanted to see if we would be open to tweaking this section to revert it back to the Senate language.
I don't think we would be open to doing that. If you want to bring, or if somebody else wanted to bring an amendment like that on the floor at this point, they could certainly do that. I think there is a potential, I think, for another amendment that addresses that issue or seeks to address that issue in part that we can talk about, and I would I don't believe Delegate Phillips is going to offer this amendment, but I would be willing to stand in his, not in his shoes, but in the packet, I think this is in the packet, 683526. It wasn't distributed? All right, well, I'm going to read it and we'll distribute it. And I'll say, let me just say this. We're going to be on the amendment, the committee's amendment first, and then I'm just going to indicate that this is one amendment that I would offer after the adoption of the committee amendment. And we'll email it out to everybody. What the amendment says is property means a building. Property does not include the land adjacent to the building. I'm sorry, does not include a land adjacent to the property. So in other words, it would just be the building. It would not be anything that surrounded the building, which would narrow it down, and they would have to have the sign posted at the entrance to the building to say whether or not someone was allowed to carry inside the building or not. Having said that, to your point, I would not entertain that change to the committee's amendment, but I know that people will bring that forward going forward. So still, at the moment, we are on the committee's amendment and not on the amendment I just described that we'll send around. And one more thing, that's fine, then I'm going to go.
Question, if I may. So part of the ruling of Bruin was that a person had the right to carry what they called like in public. So if we adopt language, and I appreciate the amendment, if we can narrow it down, it appears, without having read it, to make it more functional for a permit holder. But if Bruin requires that, a person functionally has a right to carry in public, even if we limit that down to buildings, how is that legal?
I think that this is one of the tensions in the law, and one of the questions that, in fact, the Supreme Court will have to take up going forward. Where do someone's private property rights supersede, or where is that line between private property rights and a wear carry permit? And that fundamentally, we could talk for hours about it. And in fact, we started getting into this conversation on Tuesday, and I fully anticipate we're going to talk on the floor about it. I think that there is that tension between those two areas where you need to be clear and say, as a private property owner, I have the right to decide whether I want somebody to come onto my property or not with a concealed weapon. And in this case, what this version of the bill would say is that the property owner would need to say, affirmatively, you are okay to concealed carry on my property. That, it strikes me, as consistent with the property beliefs, and for those listening down the line, I think it's consistent with certainly historical analogs. You know, if you look at the Third Amendment, something we don't talk about a whole lot, one of the reasons, the things that people really didn't like during the Revolutionary War was British troops garrisoned in people's houses and bringing guns into their houses. That, I think, is at least one of the arguments that you could use in the tension between those two arguments. But having said that, if you want to talk a little bit more about that, that's fine. But I want to get to Delegate Conway and Delegate Valentine.
I'll conclude briefly. So you're on the gas station. You could be on the area around. You pump your gas. Now you got to pay. You have to go in. What if you're at a marina? You know, what's the definition of end? Is maybe the area outside the building is the dock. What if you go up to get a chicken fingers, but you're not in, but are you in? So I still have, even conceptually, I still have some real concerns here. Like if I were a member of the public who's carrying permitted, I don't understand how I don't wrap myself up under a crime. But I appreciate the opportunity.
And I appreciate that. And I'll just say that hopefully upon adoption of the committee amendments, you know, we'll go to the amendment that I described, which I think would limit it and address one of the issues that you brought up on Tuesday, where I walk, and another issue, I go to Home Depot, I set foot on the parking outside of Home Depot. I don't know whether there's a sign or not on the door. What am I supposed to do? The idea here is you go to you're going to need to go to the building, and they're going to provide you with the ability to do it. Or if it's not there, then you don't have the ability to do it, and that's the way the law would be drafted. But with that, Delegate Conway.
Chairman, thank you very much. Is City Hall considered, in Baltimore City, would that be considered a sensitive place?
Yes.
Would the city council people, if they had wear and carry permits, be able to wear and carry inside of City Hall?
This would be inside it would be inside a government building,
Would the
so
clerk
no.
of the court, sir, be able to wear or carry if they had it into the
Would
courthouse?
a member of what?
The clerk of the court. Could they wear and carry into the courthouse?
Are they considered a law enforcement person?
No.
Then no.
What about the registered wills that they had?
They're also not a
No.
law enforcement officer, so no.
Thank you very much, Mr.
All
Chairman.
right, Delegate Valentine.
Thank you, Mr. Chair. I may be missing something, but on the very first page, where in the very first paragraph, line 6, where it says permission or posted certain sign, I've read this at first glance, and is this something that was added in your amendments? Because this is not on the original. And the very first page. I've read this like 3 times, and I'm trying to.
What's the page number that you see on the top corner?
It's the very first paragraph.
You're looking at the purpose
Or
paragraph?
the purpose paragraph. And I've reread this, and I'm thinking I could interpret it as
purpose
either
paragraph.
having been received permission or a posted certain sign.
The purpose paragraph doesn't act as statute. The purpose paragraph is
Okay.
distinct from that. That's just the purpose paragraph. So the statute is what's important inside the,
Okay.
yeah.
I just didn't understand the posted certain sign.
I understand.
Okay.
Yeah.
And then the other question I did have had to do with page 5, line 27 with fair and carnival, where you struck fair or carnival.
Correct.
And added fairground. And my question is this. As it pertains to fairgrounds, they're multi-purpose entities. So I understand if you're having a county fair, a fairground, you would assume that. But we have other functions. You can have races. Another function is gun shows are routinely held at fairgrounds, and individuals that go to gun shows a lot of times are people that would have concealed carry permits. So I just wanted that to be something like these multi-purpose facilities, would it only be for this or for, it would be anything that could occur at that location?
Okay. Nope, I appreciate that, and I'm writing that down. We'll come back to that here in a second. If we need to make a change to this based on that conversation, we'll come back to that in a couple seconds.
Thank you.
Delegate Young.
Thank you, Mr. Chair. Question for council. Is it a crime to trespass on a property of another with a firearm?
It's a crime to trespass on the property of another if they don't give you, it's a crime to to go on the property of another if they have posted either a no trespassing sign or they have expressly told you not to trespass on their property.
But there's nothing in the code that says, just in general.
Not specifically trespass with a gun. That's what this would create.
Okay, thank you for that. My second piece, which is just a comment on the same section, I do echo some of the concerns about the requirement that a property owner provide the affirmative permission. I distinguish from private property from private dwelling versus private property held out for the public, even a building. I think that giving individuals and posting on a building specific instruction that makes it clear that something is prohibited protects that private property owner's or business owner's property rights. So just putting that on the record. I know we've spoken about it, Mr. Chair. Just putting it on the record, and thank you for giving me the time.
Thank you. I think what we're going to do with regard, I think that the Delegate Valentine raises a valid point. I know that there are gun shows that happen at fairgrounds at different places. I think the challenge in trying to draft some kind of alternative to that would be challenging. And so what I would offer as an amendment to the amendment based on the conversations, well, you have one more on the amendment. Delegate Boucher.
My understanding that with the wording of this bill, if a judge has a wear and carry permit, he would be or she would be in violation of law if they entered a courthouse carrying?
No. The rules that we added on from the Maryland Judiciary address that and address their ability to be able to wear and carry. The rules that they create their own rules with regards to their employees wearing and carrying at courthouses, and that includes members of the bench.
All right, so this wouldn't affect that?
Yes.
All right, thank you.
I don't believe this would affect that. What I was going to say is, and not seeing any other lights on, is I would seek to make a motion to amend the amendment to add the letter G that Delegate Arakan recommended that was basically a typo. So we'll do that, and then we would strike fairground from from one of the items that would be a prohibited place or a sensitive location in on line 27 of page 5. And there's a motion and a second. All in favor of the amendment to the amendment, raise your hands. Anybody opposed? Now we're on the committee's amendment. All in favor of the committee amendment, raise your hands. All in favor of the committee amendments, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. Anybody opposed to the committee amendment? 1, 2. All right, committee amendments adopted. All right. All right. So we have adopted that. Okay, so because I mentioned it a moment ago, I'd like to, you now have before you that was passed out Amendment 683526. And the goal here now is to limit the scope of the public, or the, I should say the private property requirement to say that property means a building. It does not include the land adjacent to the building. So the example would be we'll go with the Home Depot, Lowe's, big box store exception, basically, where if you pull up to the place, you don't know whether or not you're allowed to have it. You would be allowed to have it on their parking lot or on their surrounding property, but if they say that you can't, that they're not allowing people to have it in the store, that would be different. Delegate Conaway.
Chairman, in the case of the courthouse and the parking lot is in the basement, is the parking lot in the building, or is it
The parking lot would be in the building.
So a person with the wear and carry could not bring their firearm loaded and all into the building. Is that correct?
You couldn't do that now. Yeah, so you can't do that now, so nothing
with
changes.
wear and carry?
You couldn't do that now and bring it into a government building according to existing law and according to Comar. Can't do that in this building.
If you're an employee of the building?
Correct.
All right, thank you.
Unless you were a law enforcement officer, that would be different. Delegate Tomlinson.
Thank you. Is this amendment also applying to personal dwellings or no? No.
It doesn't apply to dwellings. You require, as we already talked about, it requires the permission of the property owner to be able to carry on onto the property. You have to have the express permission, and that's as it stood before, and as it came over from the Senate. This only has to do with effectively not a dwelling.
But currently, or with the way the bill is written right now, does the same kind of idea apply there? I mean, if I pull up in somebody's driveway and then go up to the door and find out that they, I ask and they say, no, I do not welcome guns here, am I in violation of being in the driveway?
Dwelling means a building or a part of a building that provides living or sleeping facilities for one or more individuals. So if you were sleeping in the driveway, I guess that's true, but no. To answer your question, no.
Okay, so you would not be in violation in the driveway.
It's the building. So that's actually why that's why I'm offering 683, because it brings it in line and brings it in the same posture as what it's 683-526 brings it in the same posture as a dwelling in that it doesn't include the area immediately surrounding. Delegate Cardin.
Prohibit a private owner, like a Home Depot, from posting all the way out on their parking lot if they want to. I mean, let's say that you have a Home Depot that says we don't even want them on our parking lot, and they have fence it around and they put it there at the. I'm just wondering, because I know I would like my Home Depot not to allow it on their property at all, but I don't know.
I understand that, but this is seeking to address a concern that was expressed in the committee, and I think that it's an appropriate one. So no, they would not be able to extend that apron out into the parking lot. Because again, what we're trying to do is provide certainty under the law, best we can. There's a motion on the amendment. This again, 683-526. The second. It was Phillips's. It's now mine. Would you like it back? Would you like it back? All in favor of this amendment, raise your hands. Anyone opposed? The amendment is adopted. Okay, now we're going to go to amendments a little more interesting. Let's begin. All right, we already did this one. Just trying to keep things straight. So look at grammar 653527. Alcohol. It would strike, and he'll. Do you want to talk? All right, move.
Thank you, Mr. Chair. So on page 5, line 17, it currently says it prohibits at, let me get there myself, a location licensed to sell or dispense alcohol or cannabis for on-site consumption. So I think cannabis has its own set of problems, and I didn't want to get into that. So what this amendment does is it allows for carry on premises that serve alcohol for consumption. And I think Delegate Ericon spoke to some of the concerns here. And frankly, I think anytime there's a controlled dangerous substance, we should think about that. But the breadth and magnitude of the number of locations that serve alcohol, that 9 out of 10 people don't visit to consume alcohol, it really, restaurants, marinas, any kind of dinner location, frankly, any eatery that even sells wine. You know, they sell the wine either via glass or bottle. This is going to, frankly, prohibit most functional use for people. Like every day when I go pick up my kids and I go home, I stop at a local restaurant. I've never drank there, but I regularly purchase dinner there. And it's one of the big problems with the bill that makes it a little bit dysfunctional for use for the average person. So all the amendment does is remove the prohibition on locations that sell alcohol for on-site consumption.
Thank you, Delegate Grammer. I'd ask the committee to resist the amendment. In the Public Safety Article 5314, it's already against the law to wear, carry, or transport a handgun while under the influence of alcohol or drugs. That's why this is in here. It's already against the law to be under the influence to do that. I accept that there's a distinction between being under the influence and having a beer. But having said that, I think that it's fairly clear that the already existing intent of the law is that you cannot be able to or you should not be in possession of a regulated firearm while you're consuming alcohol and drugs. And so for that reason, I would seek to resist the amendment. We'll go to Delegate Boucher and Delegate Eric.
Thank you, Chairman. I understand what you're stating, but I must state that there's a lot of people who enter restaurant establishments that dispense alcohol who do not consume alcohol. Therefore, I find the line quite discriminatory against those individuals patronizing those establishments that do not consume alcohol. Thank you.
Yeah, so there's just a lot of concerns with this one because businesses like, you know, a restaurant can already post a sign currently and say, don't carry in here. It doesn't really matter if they serve alcohol or not. It's private property and they can already make that decision for themselves. And businesses do. Sometimes I'm out and I see businesses have a sign posted and I don't go into that business because they don't want me there, and that's fine. But this sort of de facto, I can go nowhere now, is frankly really unfair. I think it actually preempts the property rights of individuals in our state. So I won't be able to allow for, you know, friends of mine. If my last fundraiser that I had at my farm, I encouraged people to carry because it is a huge crowd of people that comes there. There was at least 250 people there. We're out in the open, and people hate me. The chair knows. My first session down here, I got multiple voice messages left on my cell phone saying that someone was going to kill me. Multiple. People don't like me, and that's okay. They don't have to. But I'm armed, and so if they do try to kill me, maybe I'll get there first. And I think that's fair that I should want people to be able to be protected at my events on my property. But this bill preempts my own property rights. That's what it actually does. So, you know, I think removing the piece about alcohol, it is very problematic. I don't see how it will stand up to judicial scrutiny. I think it falls in the end. But in the interim, people will be getting in trouble for this. People that are totally innocent, just like they did when we did the may issue standard. People got in trouble who never should have because they were not violating a constitutional law. They were accidentally, in many cases, violating transport laws because they weren't eligible for the may issue standard. So, and those people still have records, and we haven't fixed that either. So this is just going to be another situation, just like the may issue standard, where, you know, people that don't know about the law, they'll have an event at their property. They'll get a one-time use alcohol dispensary license from their liquor board. They'll ask their friends with wear and carry permits to come onto their property for safety purposes, to keep the crowd safe. I can't, what am I going to pay for armed police officers at my fundraisers now? Come on, I mean, this is crazy. So I think it falls, and I just don't think there's a reason that we should be passing legislation like this that is not really helpful. We're not saving anybody's lives by telling me that I can't have armed individuals on my property during my fundraisers. We're not saving lives doing that. So a huge supporter of this
Delegate
amendment.
Grammer, are you pressing your amendment?
Chair, nobody should be carrying who's inebriated or drinking at all. Current law already governs that. We got that covered. I think Delegate Ericon hit the nail on the head. I think the question we should ask ourselves in considering this amendment is, under Bruin, can a person be considered to have a right to carry in public when we have prohibitions that are frankly overwhelmingly preclusive from even doing that? So very respectfully, I would press the amendment, and I would ask the committee to support it. Thank you.
There's a motion and a second. These requested the amendment be considered for a vote. All in favor of the amendment, please raise your hands. Sorry, 1, 2, 3, 4, 5, 6, 7. All opposed to the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9. The amendment fails. Okay, I didn't. I'm sorry, and we're moving on off from this amendment. There are two amendments from Delegate Tomlinson. The first one, 253028.
Yes, thank you. So this amendment addresses some of the concerns that I think Delegate Phillips, Delegate Cardin, I think somebody else, I can't remember, had brought up at different times on Tuesday night about the concern that the only way that you could have really kind of an approved guard or security is if they were getting paid, receiving compensation. So this was simply just changing that to say that, I mean, I don't think it's right. I don't think, what I'm not proposing is that just somebody shows up that day, and decides on their own that they're going to stand out front with a gun and protect a place. But that if the property owner says, hey, this person's been approved to protect this establishment, I don't think they necessarily have to be paid, because I think that's where we are running into issues with. There were concerns about about some churches and schools that would love to have an armed guard, but they can't necessarily pay that individual. So this was simply just removing the requirement that they have to be receiving compensation.
Is there a second on the amendment? There's a motion and a second on the amendment. The committee, there was discussion about this point. There's been discussion about this point. The committee's intent is to make sure that there is some kind of actual, some peppercorn. I mean, let's go back to contracts. Yeah, well, we try. Yeah, there's an offer and consideration going on here where there is some remuneration, that whether it's $1 or something. And this is something, and I'm looking at Delegate Cardin because it's been in conversations that we've had on this too. It's something merely above giving someone permission to be there, because I think it requires at least that little extra step more to say that there's a true connection between the place that's being protected and the person who's doing the protecting. So that's why we added and proposed this language to say with remuneration or compensation. And so I hear what you're saying, but that's why, and I see Delegate Conway, that's why I would ask the committee to resist this amendment. Delegate Conway.
Thank you, Mr. Chairman. Now that I think about it, this could put a strange twist on separation of church and state. And I was putting myself in the position of being a pastor, and I think I would feel very uncomfortable if I would have to give one of my parishioners $1 in order for them to have their wear and carry. I mean, on our property, I feel very uncomfortable with that. Thank you, Mr. Chairman.
Thank you, Mr. Chair. I've been thinking about this, and I don't have a problem with the amendment, but I understand the committee's or the chairman's position, and I was thinking about what remuneration could be. It doesn't necessarily have to be $1. It could be and maybe, Mr. Chair, can you tell me if it could be this? That you have a form contract, a form sheet saying you agree that you have a wear carry permit. We agree that we will give you permission as long as you follow whatever rules. Make a copy of that, sign it, make a copy of that, and say to them that we're giving this form to you as our remuneration. Like, basically, you're giving them, it would be incidental in terms of what you're giving them, but you're actually giving them something that in return for their agreement to do it. To me, that would seem to be enough. It doesn't have to be, it's of value. It's probably a very, very, very minimal value, but it's the paper that it's written on.
But it could conceivably be valuable to the person who is giving it to the other person, so
if that's
now I'm
remuneration,
going to first-year contracts and I'm suffering PTSD, but okay. But having said that, I think that it would have some value, but it also acknowledges, and again, for the people who are going to be listening to this later, it acknowledges that there is some real connection, not just an ephemeral one, between the people who are going to be doing the protecting and the people who are there. Delegate Phillips, then Delegate Tomlinson, I see. Here's what I'm going to do. Delegate Phillips, Delegate Tomlinson, and then Delegate Young, then Delegate Tomlinson, and I'm going to be asking you if you want to press your amendment at the end. Delegate Phillips.
Okay. I was trying my best, Mr. Chair, to be quiet and so we could get through this. My sense is, my first year contracts, they always said, you got to put in $1, right? You got to have some value that has some market value. But to Delegate Carton's point, maybe that would do it. My thought on this was that there would just be some some agreement where the entity would have to maintain some type of a list. And I was concerned about this because I don't want it to be an after the fact, right? So that there would have to be some type of a list of individuals who were approved, and if necessary, you would be able to review that list so you know that those individuals were approved.
How about this? What if it said, instead of without remuneration or compensation, or it says with, actually, with, right now it says with remuneration or compensation. What if it said with an agreement between the parties, remuneration or compensation? With an express agreement.
With an express agreement between, great.
People fine with that?
Great.
Everybody? So would you accept that amendment to your amendment? All in favor of the amendment to the amendment, raise your hands. Anybody opposed? All in favor now of Delegate Tomlinson's amended amendment, raise your hands. All right. Anybody opposed? Seeing none. It's amended. The amendment is amended and adopted. Okay, moving right along now. Do you want to press 860? Don't want to press 863-226. All right, so we don't have to do that one. So that knocks that one out. All right, there are two from Delegate Arakan. One is a study. We'll do that one first. 723121.
Yeah, this essentially does what I think we should have already done before we took up this bill, and that is look into whether or not people who have wear carry permits are actually causing any crime. As all of you remember, we asked state police if they had this data available to us, and they did not track it. So this would simply ask them to do that before we go out and take away my right to protect my children and myself and anyone else who's standing nearby me. Why don't we look at whether or not there's actually anybody in the state who's causing problems who has a wear and carry permit. And I think that's sort of what we do on a lot of topics, frankly. HGO especially, they have a lot of studies they do before they jump into making massive policy changes that could impact the lives of 300,000 people in the state of Maryland. So that's what my bill, that's what my amendment does, and I frankly think that that's where we should have started, and it should have never gotten this far.
All right, she's moved the amendment. Is there a second motion and a second? Any further discussion regarding the amendment? Delegate Valentine, Delegate Phillips.
Thank you, Mr. Chair. I would like to echo a couple of comments on that. When the state police were in, they did have quite a few charts. They had quite a few graphs about the number surge once this decision came down last year, and as well as many of the testimony in this committee. But no one has specified, and I believe Delegate Arikan said this, and I agree, no one has said with this spike in applications, with this spike in permit holders, one instance where a crime has been committed by an individual carrying one of these permits as a result of this. And I have yet to see any data or anything on that from any of those that testified.
Thank you, Mr. Chair. This is a situation where a study is not going to cut it, in my opinion. At the end of the day, because of Bruin, I think we would not be acting, we would not be doing our jobs as legislators if we don't take on this issue. And while I'll be quite honest, not everything is going to come out exactly as any of us would like. I said that the other evening. We must take action, and we've got to fix this, and we've got to get something in place to give people guidelines. Because right now, I think we are, with this delay, right, we've got to address some legislation. We should not wait until next year to fix this. That's my position, Mr. Chair.
Okay, thank you, Mr. Chair. I just need to be clear where the training is sort of is attached. I just need to know where that is in this whole thing. And actually, it should have come first, because that should be a part of being able to get a permit. So where are we? Is there a bill that I'm missing somewhere in my head?
No, it's just not here. It's in the Senate. And so I believe as part of what they're doing with House Bill 824, and they gave me the opportunity to do a sponsor-only hearing yesterday. One of the issues that was brought up in the Judicial Proceedings Committee was the issue about training and specifically how the curriculum would be put together. Yeah. And I believe very strongly, and I would support an amendment to House Bill 824 that would allow for a curriculum to be drafted by the Attorney General's office in consultation with the Maryland State Police and perhaps with the Department of Health to address the issues that are in the training portion of House Bill 824 as it was drafted. So that is there.
Okay.
All right.
Thank you.
So that is being dealt with across the street. It's not before us today.
That's okay, as long as I know it's going to be out there.
And for the record, Delegate Grammer had an amendment to this bill, but it was more appropriate to do it to that bill than it was to this bill because the training requirements change in that bill, not this one.
And that's what provoked mine, because I saw that.
Delegate Grammer does provoke people,
And,
yes.
well, he does. But I saw that, and I've just been holding on to that piece in every vote that I've taken, that somewhere there's that mental health piece before a person gets a permit. Thank you.
Okay, all right, so I just wanted to say, unfortunately, I do have data that shows that sometimes permit holders commit suicide. And I also have data that sometimes permit holders commit homicide. Unfortunately, my data is empirical because it was right across the street from my house, where an individual who had a permission, was lawfully carrying his gun. He was a law-abiding citizen until he killed the family of his ex-girlfriend. His words were, "I'm going to kill everyone you know." And he killed the daughter, her husband, and he shot her son. Fortunately, he did not die, and he shot himself. So, unfortunately, there is data. I'm not saying that all permit holders do this, but some do. And unfortunately, we have to do this. I agree with Delegate Phillips. And also because there was an executive order that opened the doors. So we didn't have time to do a study. I think a study would have been great so that we would have had it, but we didn't have time. And then here comes Bruin decision. So those are my thoughts on that. While I think a study would have been good. I would have loved to have had the data, but we didn't have time to do it. And we do have the gun center, and they are going to pull some data for us, but we didn't have quite the time that we would have probably liked to have had. So I hope that answers your question.
Thank you. Delegate Young, then Grammer, and then I'm assuming that Delegate Arakan wishes to press her amendment. Delegate Young.
Mr. Chair, I think this data is important. I do not, however, agree with striking the entire bill. So what I would like to ask for the chair's consideration and the sponsor's consideration is to remove the striking language of this amendment and to keep the language that asks for the study.
I appreciate that, but I don't think we need to add, for the reasons that Delegates Phillips and Bartlett just stated, I don't think that this study is necessary.
May I follow up, Mr. Chair? Mr. Chair, my district is one with much gun violence. We all know that. There was a murder just last week right behind my house where 3 people got shot. There was a body that was left in a car at the top of my block just 2 weeks ago. This is, at the end of the day, gun violence is gun violence. And if we're going to restrict legal gun owners, we don't talk about legal gun owners being a problem in the 45th district. It's the illegal guns that come to my district that are a problem. And I'm not trying to minimize anybody's concern about guns as a whole, but for me, having a clear picture of all the guns that are being used, who has them, who's using them, in what cases that they become problematic, that's valuable information for folks in my district. That's valuable information for me as I think about public safety in Baltimore City. So I would just ask that we reconsider my request.
Second. No, I'll just second the motion of Delegate Young.
Okay, we're on an amendment here that I'm not going to, the amendment seeks to add a study and get rid of the bill. That's the way that this is drafted. The chair, we don't need to add the study on top of this in the chair's opinion, but I know that Delegate Arakan wants to press the amendment as it's drafted, so we're going to go ahead and do that. I'll give you the last word on the amendment.
Yeah, I'll just say one case, like Delegate Bartlett mentioned, data does not make. In fact, having only one case that was able to be pulled up, in fact, proves what I've said, that it's very likely that permit holders are not causing the majority or even close to accept Delegate Young's amendment to my amendment, should the chair want to reconsider it. Otherwise, I will press my amendment.
I think we'll go ahead and press the amendment in any case. Delegate?
Look up anything. I just simply thought about what happened across the street from my house. I never looked it up. I just want to make it clear that I didn't look up the data, and if I looked up the data, I probably would have found more incidences. But we can do that offline. Thank you, Mr. Chair.
Delegate Arakan's amendment is 723121. All in favor of her amendment, please raise your hands. 1, 2, 3, 4, 5, 6. All opposed to her amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. The amendment fails. On to Amendment 353, and here I do have a recommendation for Delegate Arakan. The question that came up during the hearing had to do with what happens with a person who has a wear-carry permit. Delegate Arakan has an amendment 353125. And the issue became a almost circular argument because on the back of a wear and carry permit, it says that a wear carry holder was not allowed to go anywhere not allowed by law. And so I've seen plenty of the permits now. I've got a copy of a permit. And so in consultation with attorneys and trying to find a way forward, there's a portion of the wear carry statute that needs to be, that we think by deleting this, it will address the issue that is being raised. And what would happen is in the public safety article, in 5307B, it reads as follows: the Secretary may limit the geographic area, circumstances, or times of the day, week, month, or year in which a permit is effective. I believe that under the Bruin decision, that clearly falls afoul of it because it's a subjective standard and not an objective standard. I also believe that that is the reason that that language appears on the card. So by deleting language that we need to delete anyway, we would address the language on the card, but then we would also strike the portion of the wear carry statute in the criminal law that says, this is how it reads as a whole, then I'm going to read it as it would read without the language excised. The wearing, carrying, or transporting of a gun in compliance with any limitations imposed by 5307 of the Public Safety Article by a person to whom a permit to wear, carry, or transport the handgun has been issued under Title V, Subtitle 3 of the Public Safety Article. So in other words, in the crime that exists at 4203 and 4203B2, there is language that effectively creates this circular problem with the card that says that if you have it in a prohibited space, then you would be violating the permit. I believe that by deleting both 5307B, where the Secretary can limit the geographic area, as I said, and deleting the following words, in compliance with any limitations imposed under 5307 of the Public Safety Article, we would simply be excising that out, and that would address that issue. So the part of the wear carry statute would then read, the wearing, carrying, or transporting of a handgun by a person to who, wait a second, but the wearing, carrying, it would strike the reference to 5307 in the wear carry statute. Delegate Arakan, I know I'm just reading this, but that's what we've been trying to figure out, is how to address this issue that came up during the conversations that we had on the bill. And I think that by deleting those areas of the law, it addresses that issue, because then it not only gets rid of unconstitutional language, it also addresses sort of the circular argument that we ran into with that language on the card. And then the lenity language that exists in the bill would keep it to the 1-year penalty for people who had a wear carry permit, a 3-year penalty to people who don't get the permit. So I'm looking to Delegate Arakan, because I'm willing to make that amendment on my own. I would like to make that amendment with the understanding that you'd withdraw yours, or we can amend your amendment, but we end up getting to the same place. But go ahead.
There we are. Yeah, I mean, that seems like a good thing. So your plan is to remove 307 completely from the code. Can that be done in this bill? Or
5307B.
Right, 5307B.
Yes,
right,
I believe
yes.
it can.
Okay, and then I'm just trying to make sure there's no other places in the bill, because the amendment that I drafted affects a bunch of different places, but your feeling is that from now on, when we get our cards issued every
That language wouldn't exist
3
on the
years,
card.
then it would no longer be on the card.
Right,
And then no
but
longer
you
be
would still
taught.
be prohibited from the specific areas. It just wouldn't appear on the card to act as a 3-year violation of the wear carry statute, just the 1-year violation.
Okay, and then how will we handle, because my card's obviously good for a significant period of time before I would renew. A lot of our cards will still say that, and a lot of us were already taught that, and then we never get taught again. Do you know what I mean? So how will we be notified that that policy is different now?
When we passed 824, there was references to Maryland state law and state law that would include this area. That's language that is still in the bill across the street and is part of the training program. So it's going to be part of ongoing training that happens under the bill that is being considered in the Senate. I would just say, what we would be doing would be cutting that feedback loop, and with the anti-lenity language that's in the bill, that should address any problems that people would have on that score.
Okay, so the other side's bill, so now when I go to renew, do I have to retake the class? Or can we just direct the secretary?
That's the bill over there. That's not touched in this bill.
Yeah.
That's the bill that's there, and that, when that comes over here, we will know what they actually do on that bill, and so I don't want to get into that discussion
Yeah,
until that actually
my
arrives.
only worry is just making sure people know that the law is changing, because I know because I'm here, but most people who already have their permit, when we go to renew, we just apply to renew. There's nothing that we don't go back to the class, we don't do any of that stuff.
understand
So,
I understand that, but the practical problem that you had identified that I'm seeking to address here
Yeah, for
is
prospective.
that is the practical issue that I'm trying to address.
Yeah.
And I think that this deals with that practical problem.
yeah, I think this is a good fix, and, yeah, I'm fine with amending
Right,
in that way.
so it's what I don't like to do. It's an unwritten amendment, but I've been trying genuinely to figure out how to address that issue. So again, what would happen is we would strike unconstitutional language in 5307B of the public service article, or public safety article, public service commissions upstairs. And that deals with how the secretary can deal with limiting the availability of concealed carry at certain days of the week, and then strike the relevant portion out of the wear carry statute so that people don't get caught in this. All in favor? There's a motion. Is there a second? Motion and a second on the amendment. All in favor of the amendment, raise your hands. Anybody opposed? That amendment's adopted. All right. So, okay, are there other amendments? Delegate Tolles.
Everyone has the amendment I have. I don't know. You have that, Mr. Chair?
Yes?
Thank you. I thought you forgot about me because you said, were there any other amendments? So I would just say that I will not press the amendment. I work, with the committee. I know we're trying to move it, and we've had several amendments. And I know you and I, discussed it. I do believe that we need to be able in the future to look at individuals who are experiencing particularly severe domestic violence cases, and the court can determine, if they can be, not part of the exceptions from, having a firearm to protect them if they feel it's such a severe case where you have maybe a child abduction, or you have some type of, situation going on domestically, where they feel that victim needs to be protected, even in places that are exception. Like if they take their kids to the park and they can't bring it there because it's a safe space, but their perpetrator know that's where they're going to be and have had, severe cases from that. So I hope that we can look to something like that in the future to deal with this issue, but, I will not press the
I'm
amendment.
happy to speak with you further in the future to see what, if anything, we can do. Delegate Card.
But I'll maybe talk to you as we go onto the floor. If there's a friendly way to handle the issue that I brought up, maybe we can work on that.
I'm happy to discuss that with you. We will have a little more time to do that, I'm sure, but I think at the moment we are where we are. There's a motion for a favorable. Is there, as amended, is there a second? Motion for a favorable and a second. Further discussion, final discussion on the bill, which will last no more than 5 minutes. Delegate Grammer.
Thank you, Mr. Chair, and I appreciate the work to address some of the concerns to make the bill practical for permit holders. I do, thinking back to Bruin, you know, the general premise was that we need to, protecting the rights of people to carry means protecting their ability to carry in public. And I think the bill, even having addressed some of the concerns, I think the bill goes radically too far. I think we should address some of the other concerns before moving this. That's why I'll be a no today, and I think we'll probably hear more about those concerns going forward.
Delegate Boucher, then Valentine.
Thank you, Chairman. You mentioned earlier about training and a need for it. It made me realize that there's nothing in here about general liability for people who have wear and carry. I know that as a motorcyclist, you take the course, you get a discount insurance. There's been no mention whatsoever about the liability of people walking around with weapons. Does that play into this bill an argument about people being insured to carry in public, and if they do have insurance, having discounts for having been trained to motivate people to get the training?
With 4 days remaining, I will tell you as a younger delegate that I spoke to several people about whether or not to require insurance for people who were in possession of a wear and carry permit, and it didn't really get very far. But if you'd like to take up that issue in years to come, I look forward to speaking to you.
Well, I might not ever get elected again.
Oh, well, that's fine. I sense that could be a thing. But having said that, Delegate Valentine, then Delegate Tomlinson, then we're going to vote.
Thank you, Mr. Chair, and I just wanted to take a moment. I wanted to say that I empathize with the good delegate and her experience, and I do appreciate that comment. I just wanted to say that I empathize with that. My personal experience and professional experience kind of goes in another route, and I just wanted to say that in all of the years of law enforcement, I had only had one instance where I was involved in a situation with an individual with a concealed carry permit that was charged with a crime, and that was a collateral situation where he was just happened to be in the wrong place at the wrong time on a drug search warrant, had nothing to do with his concealed carry permit. It's been my vast experience that individuals with these permits, in my experience, are not the individuals committing crimes, and I just wanted to have that put on the record from my personal experience. No data, just personal experience. Thank you, Mr. Chair.
Delegate Tomlinson.
I'm just going to bring up what I was trying to talk about earlier, but I said I'd wait till we were actually on the bill. So back to what I was asking about with page 10. When we say the owner has given express permission, that means either a sign or what, just a verbally saying that they
would have to have given them express permission in a way similar to a person who would be seeking to be able to enter into a property but might be subject to a trespass restriction because the sign was posted no trespassing. So it would be express permission. You are able to come onto my property with a firearm, with a regulated firearm that you have a wear carry permit for.
Okay.
All right. The last comment, Delegate Eric.
I can be loud, but some people are hard of hearing. It's coming. Okay. Oh, it's unconvinced. Okay, it's back. Okay, so I do appreciate that there's been a lot of work on this bill, and, you know, for those who haven't been here, you know, over the last 5 years or so since Delegate Clippinger has taken over our committee, you know, there's been a lot of gun bills that we've seen, a lot of things that we've worked on, but I will say that this feels like a bill that a lot of us have touched, which doesn't always happen. Frankly, it almost never happens, so I'm thankful for that. I still obviously have grave concerns about the policy direction that we're taking with this bill, just because I don't think we have any evidence that it's actually going to help us. And it feels like a punishment. It feels like many people, especially the majority party, feels like they were personally attacked by a court ruling, and this feels like political whiplash to me. It doesn't feel like good policy. It feels like people who are mad and who want to take out their feelings of anger on me and other people, the other 300,000 people in this state who carry firearms like I do. So that's disappointing. It happens, I'm sure, in every state, even states where, you know, people from my party are running things. I'm not going to say that we're immune to it. We certainly aren't. But it does hurt, and it's always sad to me when policy is being driven by only emotion and not by sound reason and data. And so for that, I will be a red.
We're on the bill as amended. We'll do the roll call. The Vice Chair. Yes. Munoz is excused. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. No. Simmons. Yes. Boucher. No. Phillips. Yes. Tomlinson. No. Erican. No. Taylor. Yes. Simpson. Yes. Grammer. No. Young. You can explain your vote. You have to cast it first.
Say yes, and the brief explanation is, I do have concerns about the affirmative permission, but thank you to the Vice Chair for sharing with me that no one gets any time for where carry violations. So for that reason, I will reluctantly but affirmatively vote yes. Thank you, Mr. Chair.
Delegate Valentine? No. Yes, please.
I'd just like the chair to know that I do appreciate his consideration on the one topic that I did bring up.
Thank you. Delegate Kaufman, please.
Yes, and just a brief explanation. I will be voting for this because I Republican constituents, Chief Justice Roberts and Chief Justice Kavanaugh say that this is legitimate, then I'm going to be supporting it. And I also just want to thank you, Mr. Chair, for the courtesy that you've shown to the minority party. That doesn't happen on Capitol Hill where I work. They just shove things down your throat, so it says a lot about you, sir.
Okay. Delegate Conaway? Yes. Williams?
Yes.
Yes, the motion is adopted. Thank you all very much. Listen for future voting sessions.